Preliminary list for the case item 4, second appeal 136 of 2022.
Findings of this court. It is an undisputed fact on record that the property belonged to, the suit property belonged to Lakshmi Narayan Das, great grandfather of the plaintiff, and his son Satyanarayan Das, grandfather, and also sons of Satyanarayan Das succeeded the suit property in the year 1944. It is further not in dispute that a decree was passed in favor of Nagesh Chandra Agarwal with a decretal amount of rupees 26,700. And properties which were in possession of Satyanarayan Das and his family members was attached. And in the meantime, Satyanarayan Das also expired. The decree was passed in, the money decree was passed in by Honorable Kolkata High Court in money suit number 1361 of 1955. As per the plaint, Nagesh Chandra Agarwal prevailed upon Satyanarayan Das to execute a fictitious deed at Malda to avoid tax liabilities. it has been asserted in the plaint in paragraph 5 that to avoid tax liabilities, late grandfather was prevailed upon by Nageshwar Chandra Das of Calcutta to execute a fictitious deed wherein correct plot number at Malda with respect to suit property, wherein the property situated at Rajmahal and incorrect property at Malda and fictitious property at Malda were also included, although no such property existed in Malda. The fictitious deed was due to क्या है? What is this written?
Collusive money suit filed by
Due to a collusive money suit filed by late Nagesh Chandra Agarwal at Kolkata. During the course of arguments and from the perusal of the records of this case, it is not in dispute that this statement was referable to the sale deed. Was referable to the deed dated. डेट बताइए तो deed का डेट बताइए.
24 to 1960.
24 to 1960. Exhibit B. The relief prayed for in the suit. No relief was prayed for in the suit with respect to Exhibit B. Rather, the plaintiff had made a prayer with respect to the subsequent title deed executed by Harishankar and others by registered deed number 6147 of 1987 and which was registered at Calcutta by asserting that the defendant first party had acquired no title by such deed. The perusal of the plaint reflects that no further or other allegation was made in connection with the aforesaid deed Exhibit B. And the plaint also does not disclose as to when and how the plaintiff came to know about the aforesaid deed, which was alleged to be a fictitious deed of the year 1960. The plaintiffs claimed that they remained in possession of the suit property throughout. They and / their ancestors remained in possession of the suit property throughout, and at no point of time the possession arising out of the said fictitious deed or subsequent deed was handed over to Nagesh Chandra Agarwal. And the plaintiff sought confirmation of possession over the suit property. Appellate court has not given any finding with respect to possession. They have given? They have not given any finding with respect to possession. However, the learned, आप देखिए थोड़ा सा आराम से देखिए. However, the learned trial court had framed a specific issue with regard to issue number 7, with regard to the aforesaid sentence dated 24/2/1960 with the bracket SBB, which is as follows: Roman 7. The learned trial court, while considering Exhibit 7, has held that the said deed of 1960 with the bracket Exhibit B, though was termed as Bhagna Nama, but it was essentially a said deed. With respect to properties relating to Raj Mahal and also properties situated at Malda, and the same was executed in satisfaction of the decree passed in money suit number 136 of 1955 by Honorable Kolkata High Court for an amount of rupees 26,700, and further rupees 7,000 was paid as consideration. And this all happened because of the fact that Satyanarayan Das had expired on 13/12/1957, and the widow and her children were required to maintain themselves. It has been also recorded that due permission to transfer the property under the provisions of Hindu Adoption and Maintenance Act 1956 on behalf of the minor children were taken by the District Court at Malda with respect to the transfer of the suit property, and the major sons had also joined for the transfer of the suit property in the execution of the sale deed of 1960 Exhibit B. The learned trial court, while deciding issue number 9 relating to possession of the suit property, has given specific finding that the plaintiffs were in possession of the suit property and their defendant, that the plaintiff was not in possession of the suit property, rather the entire suit property, rather they claim over plot number 60, 61 and 65 was confirmed, in connection with which there was no dispute. The learned trial court considered the materials on record and including the order passed under section 145 and 107 of CRPC. Under section 145 of CRPC, in TR case number 3 of 87, in which the possession of Nagesh Chandra Agarwal through Jagdish Narayan Agarwal was confirmed, and also observed that nothing was brought by the plaintiff in support of his possession over the suit land. And ultimately held that the plaintiff failed to prove their possession over the suit property. So far as the learned first appellate court is concerned, it also framed the points for determination as quoted above, and entered into the legality and validity of the title deed of the registered deed of the year 1960, which, as mentioned above, was never the subject matter of challenge before the learned trial court, although in the body of the plaint they alleged that a fictitious deal was entered into in the year 1960. It is in this background the learned first appellate court held that the widow of Satyanarayan Das had no right to transfer the property as she had only right of maintenance. Further, semicolon, the defendants were not able to prove that they had property at Malda so as to give jurisdiction to the court at Malda to grant permission of transfer under the provisions of Hindu Adoption and Guardianship Act, semicolon. The deed was a Brahmannama deed, being a mortgage deed, and the onus was upon the defendant number 1 to prove that the document was a sale deed. And also that the sale deed was created without taking permission of Honorable Kolkata High Court in the execution case in which the property was attached to which and the property was charged in the execution case, and in absence of such permission the deed could not have been executed. It was held that the alleged document of 1960, executed by grandmother of the plaintiff without any right in the eyes of law, was invalid, void ab initio, and consequently the subsequent deed of 1987 also did not pass on any title in favor of the defendant number 1. Consequently, the deed of 1960 was held to be void ab initio. Is there any finding on possession by the learned first appellate court?
No.
Finding दिखाइए.
No finding.
You show me one line. हमको नहीं मिला पूरा कुछ.
नहीं, there is no finding with regard to Partition by the appellate.
Yes. Is there any finding? Point of determination number 3 and 7, para 12 में देखिए.
इस point number 4 है at page, internal page 12, running 34. इसमें concluding part है. With regard to mutation, kindly come to page 30, last 5-6 lines.
So in the record of rights, the name of Nagesh Chandra Agarwal has not been shown by respondent number 1. No khatiyan has been filed by respondent number 1 to prove Bharnanama land of subdivision Rajmahal was ever mutated in the name of Nagesh Chandra Agarwal. So the point of determination number 4 is against the respondent number 1 and in favor of the applicant.
No, where is the point for possession?
Yes, that is the point. Only when it
पोजीशन का फाइंडिंग है,
ये उनका म्यूटेशन नहीं हुआ.
म्यूटेशन नहीं हुआ है. पोजेशन का फाइंडिंग आपके फेवर में है that you are in possession of the property.
इनका cause of action था मेरा mutation.
कोड नंबर तो वही फ्रेम किए हैं कि whether the respondent number 1 has
पोजेशन दिखाइए ना that you are found in possession of the property.
certain plots पर तो ट्रायल कोर्ट ने ही कहा, कोई चैलेंज भी नहीं.
ठीक. Is there any specific point of determination with regard to possession?
म्यूटेशन तो उनका नहीं मान.
Possession का कोई specific point of determination है?
नहीं.
The learned appellate court has taken view.
No,
Right.
is there any specific point of determination on the point of possession?
But the learned trial court has considered this issue
Yes.
and has said that on certain plots the plaintiff were in possession and accordingly had decreed the part.
That's
Appellate court has said regarding possession on the ground that the mutation is in the favor of the Nagesh Chandra Agarwal. Then all these documents has been interpreted and it has been said that after the exclusion of that Varnanama deed, there was no mutation, never any mutation in the favor of Nagesh Chandra. So there was no, and because there was no position with respect to the land.
physical possession तो अलग बात है ना. Is there any finding on physical possession?
Physical possession पर तो ऐसा नहीं लिख रहा है, लेकिन
So far
दोनों
as
साइड से इसमें
just a
फलकार बिक्री
So
नामा
far
का
as-
डॉक्यूमेंट्स आया.
so far as the point regarding physical possession of the property is concerned, no specific issue as such was framed by the learned first appellate court, nor any specific finding has been recorded as to who was in physical possession of the suit property covered by, or the property covered by the Exhibit B. However, the court has discussed that there has been no mutation in favor of Nagesh Chandra Agarwal, Nagesh Chandra Agarwal, pursuant to the sale deed of the year 1960 Exhibit B.
पोजीशन का डॉक्यूमेंट में दोनों आदमी के तरफ से
कोई बात नहीं.
एग्जिबिट्स का एक डिस्कशन हुआ.
ठीक.
ये भी कहते हैं कि हम फलकार बिक्री नामा हम भी लाए हैं, हम भी लाए, दोनों आदमी लाए.
Although the learned trial court, while considering the point of possession under issue number 9, had recorded a finding based on materials including the order passed under section 145 and 107 of CRPC that Nagesh Chandra Agarwal through Jagdish Chandra Agarwal was found in possession. With respect to the suit property over which they were claiming, with the remaining property, the defendant had no claim. It was in this background that, on the one hand, allegation of the deed of 1960 being a fictitious deed was made in the plaint, but no such relief was prayed for by the plaintiff in the plaint. But considering the nature of dispute involved between the parties, an issue was framed with regard to the legality and validity of the deed of 1960 within bracket Exhibit B. This court, by framing the substantial question of law, has touched upon both the points firstly regarding the interpretation of the Salary number 3576 dated 25/2/1960 within bracket Exhibit B, and also with respect to the point of limitation under Article 59 of the Limitation Act 1963. The law is well settled that the point of limitation has to be considered by a court irrespective of whether specific plea to that effect is raised by one or the other party. On the one hand, the counsel for the appellant has submitted that the challenge to the deed dated 24/2/1960 within bracket Exhibit B was barred by limitation, and even in case of fraud or deed being, even in case of fraud and similar allegations, the date of knowledge becomes important and fraud is required to be proved, and therefore Article 59 comes into play. For this, they have relied upon the judgment passed by Honorable Supreme Court in the case reported in the case of Abdul Rahim Supra, which in turn had relied upon the judgment passed by Honorable Supreme Court reported in bracket 1996 bracket 07 SCC 767 Mohammed Nurul Huda versus Bibi Rafunisia. On the other hand, the argument of the respondent plaintiffs is that once the deed is void ab initio, the point of limitation has no role to play, and it is nullity right from inception, and void deeds can be avoided without specifically challenging the same. Correct? For this, he has relied upon the judgment passed by Honorable Supreme Court in the case of Prem Singh, Super. Both the parties have made extensive arguments on the point as to whether Exhibit B was a Brahmannama or it was a sale deed. It is certainly not in dispute that the deed was termed as Brahmannama and the vendor was termed as vendor was termed as Data and Vendi was termed as Grahita. And the term Lekhakari and Lekhadari has not been used in the deed. Further arguments have also been advanced with regard to the legality of the deed of 1916, that the same could not have been executed at Kolkata and no permission could have been granted by the district court at Malda.
There is one word used in the same consideration.
I'll just come to that. वो सारा आपका रिकॉर्डेड है, लेकिन हम अपना फाइंडिंग में आपका मोटा मोटी चीज नहीं लिखाएंगे तो कैसे फाइंडिंग? And it is a specific case of the plaintiffs that such deed could not have been executed in satisfaction of a money decree in which the property was charged.
It's on number 21.
The perusal of the Exhibit B cannot be seen in isolation in view of the fact that it is backed by a permission granted by the district court at Malda in the state of West Bengal under the provisions of Hindu Minority and Guardianship Act. The permission has been, which was granted by the order dated 21/9/1959. The permission so granted has been brought on record by the Exhibit D-2. The permission so granted is quoted as under. The permission reveals that the application was filed by the mother on behalf of 2 minor children and 1 daughter with respect to Schedule A properties. The application for permission has been also exhibited before the court. Marked as Exhibit D.2.A, which reveals that the 3 children, namely Ganga Narayan Das, Sri Narayan Das, and Ambika Das, were minor children, and the mother, being the natural guardian, was seeking permission to dispose of the property, and she was shown as wife of late Satyanarayan Das. The application for permission reveals that all disclosure was made in connection with the money suit decided at Kolkata, and that the property was attached, and also that the consideration amount would be 7,000, and it was in connection with satisfaction of money suit, decree passed in money suit. The Schedule A property to the application was in 2 parts. Schedule A within bracket 1 related to the property at Rajmahal in the district of Durga, falling under the then state of Bihar, and the property at Malda, which was admittedly falling under the state of West Bengal. The Schedule A and Schedule A property to the application is also quoted as under. The Exhibit B reveals that the deed was executed by all the children of Satyanarayan Das and by all the legal heirs and successors of Satyanarayan Das and Madhumalati Devi, wife of late Satyanarayan Das, was representing the minor children, and the major children had joined in the same deed, in the deed. The deed In this background, and upon perusal of the deed, this court is of the considered view that the finding of the learned first appellate court that the permission to execute the said deed was filed by grandmother when she had major sons available on that day. The right of grandmother to execute the said deed was questionable, and that the female had very limited right to property during the period from 1929 to 1930 till 1956. It was this finding which became one of the reasons to hold that the deed was void ab initio. However, the records of the case, as pointed out by the learned counsel for the parties and referred to during the course of arguments, and full text of these documents have been read during the course of argument, revealed that the permission was granted to the mother being the natural guardian of minor children only, and the said deed was executed by mother on behalf of minor children and on behalf of herself, and so far as the major children are concerned, they joined in at the time of execution of the deed. I think factually तो कोई incorrect नहीं है, factual incorrect नहीं होना चाहिए. In such circumstances, the finding of the learned first appellate court in this connection with respect to competence of the mother to execute the deed is not in accordance with law and not based on appreciation of materials. Further, this court also finds that so far as the nature of the deed is concerned, admittedly the same has been termed as Bharnanama, showing the consideration amount as and rupees 7,000 has been specifically referred to as the consideration amount with respect to the property. And further, it has also been recorded that the deed was in satisfaction of the money decree in title suit number in the case in the title suit in which decree was passed to the extent of rupees 26,700. And that the decree was fully satisfied. deed also revealed that it was essentially a sale deed for consideration. The sale deed, which was subject matter of consideration, was required to be considered by the court on the face of the recitals made therein, and mere title of the deed showing it as Bharnanama and using of the term Grahita and Data will not decide the nature of the deed. The finding of the learned First Appellate Court that it was for the defendant to show, to prove that it was not a Bharnanama by giving evidence is not the correct way to consider the deed, inasmuch as the deed was required to be considered on the face of it, and the recitals and the transactions recorded therein. In order to interpret the true nature of the deed, no further evidence was required. It was the deed itself which was required to be taken into consideration. The learned First Appellate Court has recorded a finding that the learned court has wrongly recorded that the major sons were not party to the deed. ये आपने बताया था ना? Has wrongly recorded that the major sons were not party to the deed. ऊपर ये sentence बहुत important. The learned court has recorded that in the deed, nowhere it has been mentioned that the land in subdivision Rajmahal has been conveyed to the ancestor of defendant number 1 without any encumbrance, and on this ground the document has been found questionable. This court is of the considered view that for a document to be a sale deed, it is not an essential condition that the deed should disclose that it does not have any encumbrance. sale deed or transfer deed can also be executed with encumbrances, if any. And the title can pass, and the vendor can pass the title only with respect to the title which he possesses and nothing more. Therefore, merely non-mentioning that the property did not have an encumbrance has no bearing with respect to the nature of the sale deed, nature of the deed being a sale deed. Once all the basic ingredients of the sale deed finds mention in Exhibit B. In view of the aforesaid discussion, the scope is of the further, the learned First Appellate Court has recorded that due permission was not granted by the executing court at Kolkata with regard to settlement out of court in connection with the money decree, for which the learned counsel for the respondent has heavily relied upon the judgments passed by Honorable Supreme Court reported in AIR 1997 Supreme Court 1006, and also the judgment which follows this judgment in reported in bracket 2007 bracket 7 SSC 240, and has in particular interpreted the provisions of Order 21 Rule 2 within bracket 3 of CPC. CPC Jaji. Order 21 Rule 2 of CPC is quoted as under. The perusal of Order 21 Rule 2 within bracket 3 reveals that a payment or adjustment which has not been certified or recorded as per provision under Rule 2 shall not be recognized by any court executing the decree. The provision does not say that it has got no value so far as courts other than executing the decree are concerned. The provision of the aforesaid provision, the Honorable Supreme Court, by interpreting the aforesaid provision, has held in was considering a case as is apparent from paragraph 6 of the judgment reported in 2007 7 SSC 240, that the point which arose for consideration before the court was whether, in view of compromise entered into between the parties and execution of a new lease deed, the ex parte decree dated 2/5/1990 got extinguished, and as such the appellant could not get possession on the premise in execution of the existing decree. The plea of compromise was taken before the executing court, and the Honorable Supreme Court ultimately held in while interpreting Order 21 Rule 2 Sub-Rule 3 of CPC that Sub-Rule 3 prohibits every court executing the decree from recognizing a payment or adjustment which has not been certified or recorded by the court under the aforementioned sub-rules. This court finds that had the parties proceeded in connection with the execution of the decree, the executing court could have entered into the issue as to whether this compromise could be entertained or could not be entertained. But when the compromise, when the settlement between the parties in satisfaction of the decree was entered into amongst them and was incorporated in a deed, it cannot be said that such kind of arrangement cannot be recognized or considered by any other court, including the court where the suit was filed in the present case. The fact remains that the arrangement which was made through the deed exhibit B of the year 1960 was to the full satisfaction of the money decree. In the plaint, no allegation was made with respect to the fact as to what happened in the executing court dealing with the money decree. And ultimately, there was no opportunity for the बस ऐसा कोई एलिगेशन तो नहीं लगाया प्लेंट में. This court is of the considered view that the learned first appellate court has erred in law by holding that the arrangement entered into between the parties has no value in the eyes of law in absence of its confirmation from the executing court. The judgments which has been relied upon by the learned counsel for the respondent, plaintiff, does not help the plaintiff in any manner, as Sub-Rule 3 refers to the recognition of payment or adjustment by any court executing the decree, and it does not refer to all the courts. And the same does not have the effect of making the sale deed null and void or void ab initio on the face of it. This court also finds that और कोई रीजन था इनका, सारा रीजन हो गया, कोई और रीजन बचा है? the fact remains that the deed was entered into by stating that it was in satisfaction of the decree, and the decretal amount was also 26,700. So part satisfaction या compromise का कोई बात नहीं.
That was agreed upon in between parties.
हाँ, and it was agreed upon between the parties. It is not the case of the plaintiff that such agreement was fraudulently arrived upon, and no such foundational pleading is there in the plaint. The law is equally well settled that in case of fraud, misrepresentation, etc., there has to be specific pleading, and the evidence is also required to be confined to such pleadings. Reference may be had to Order 7, Rule 4 of the CBC. The another part of the accordingly, it is held that the Brahmannama is essentially a sale deed executed by the legal heirs and successors of नाम भूल जाते हैं, Satyanarayan Das in favor of Nagesh Chandra Agarwal, who subsequently transferred the property in favor of the father of the sole defendant. नागेश चंद्र दास अग्रवाल को तो पार्टी भी नहीं है.
Shankar was son of Nagesh and he had sold it directly to defendant number 1.
In case of fraud, जो fraud किया है उसको भी तो पार्टी बनाना पड़ेगा. तो उनके लीगल हेयर को सक्सेसर को बनाते ना पार्टी. उनका हेयर सक्सेसर भी तो पार्टी नहीं. Admittedly, the deed was executed in favor of Nagesh Chandra Agarwal. ना जरूरत नहीं पड़ेगा. That is sufficient. So far as the applicability of Section 59 of the Limitation Act is concerned, मेरा 2 किताब आया. It has been held by the Honorable Supreme Court in the judgment reported in the case of Prem Singh. In paragraph that when a document is valid, there is no question arises for its cancellation. When a document is void ab initio, a decree for setting aside the same would not be necessary, as the same is non-est in the eyes of law, as it would be a nullity. And Section 31 of the Specific Relief Act refers to both void and voidable documents. It has also been held that Article 59 of the Limitation Act applies specifically when a relief is claimed on the ground of fraud or mistake. It only encompasses within its fold fraudulent transactions which are voidable transactions. And Article 59 would be attracted when coercion, undue influence, misappropriation or fraud, which the plaintiff asserts and is required to prove. Article 59 would apply to the case of such instruments It would therefore apply where a document is prima facie valid, and it would not apply only to instruments which are presumptively invalid. Paragraph 15(2). Of the aforesaid judgment is quoted as under. In the same judgment, it has been held in paragraph 27 that there is a presumption that the registered document is validly executed, and a registered document therefore prima facie would be valid in law. The onus of proof, thus, would be on a person who needs evidence to rebut the presumption. And in the said case, the respondent number 1 was not able to rebut such a presumption. It has also been held in paragraph 28 that if a deed was executed by a plaintiff when he was minor and it was void, he has two options to file a suit to get the property perpetually conveyed thereunder. He could either file the suit within 12 years of the deed or within 3 years of attaining majority. And since the step was not taken within the mandate of law, the suit was held to be barred by limitation. Paragraph 27 and 28 of the aforesaid judgment is quoted as follows. In the judgment passed in the case of Abdul Rahim Supra, it has been held in paragraph 19 that the suit for cancellation of transaction, whether on the ground of being void or voidable, will be governed by Article 59 of the Limitation Act. And therefore, the suit has to be filed within a period of 3 years from the date of knowledge of the fact that the transaction which according to the plaintiff was void or voidable. And the suit in the said case having not been filed within a period of 3 years, the suit was held to be barred by limitation. Paragraph 19 of the aforesaid judgment is quoted. By applying the aforesaid principle of law in the facts and circumstances of the present case, this is a very peculiar case where the deed of 1960 has been alleged to be fictitious in nature. Without giving the exact details of the deed in the plaintiff. But it was essentially but the allegation in paragraph 5 of the plea was essentially referring to the deed of 1960. Further, the plaintiff also does not give any detail, does not mention that the plaintiff had no knowledge about the deed, nor any date of knowledge has been mentioned, nor any date has been mentioned as to when the plaintiff attained majority. He was a minor.
Plaintiff was not born. Plaintiff's grandfather was the Satyanarayan Das and his father was the one who executed the deed. Plaintiff was not born at that time.
Okay. And plaintiff was not even born at the time of execution execution of the deed. And during their lifetime, none of the persons who were party to the deed had challenged the deed. The relief also does not challenge the deed. It only mentions about the subsequent deed being not binding. The plaintiff appears to have tried to escape the rigors of limitation in the plaint. However, the point of limitation having been framed by this court finds that the parties had contested the suit with regard to the legality and validity of the deed, and it was never the case of the plaintiff that on the face of the document it is invalid in the eyes of law. This is over and above the fact that the Honorable Supreme Court in the case of Prem Singh has clearly held that the registered document has to be taken as prima facie valid. The fact also remains that in the deed, the properties of Malda as well as Rajmahal both were included. And the fact also reveals that the permission was also taken with respect of properties situated at Malda as well as Rajmahal. The argument that there was no property at Malda and it was wrongly shown in the permission and also in the deed is essentially a question of fact which requires evidence. Therefore, it cannot be said that the deed was ex facie invalid and could be declared to be void ab initio without any evidence. In such circumstances, the plaintiff has not been able to clear the rigors of limitation under Article 59 of the Limitation Act, and it is held that the challenge with regard to the legality and validity of Exhibit B, a registered sale deed of the year 1916, was barred by limitation. And once the challenge is held to be barred by limitation, the merit of the challenge has no relevance if the challenge itself is held to be barred by limitation. However, since the parties have advanced arguments in connection with the legality and validity of the deed, and considering the nature of substantial question of law framed by this court, these aspects of the matter have also been considered. The substantial question of law having been answered in favor of the appellant, the judgment passed by the learned first appellate court cannot be sustained in the eyes of law, which is hereby satisfied. First appellate judgment trial court judgment will revive.
That is the position has been given with respect to the land,
That's
which
right.
is not in the deed.
That's right.
Therefore, we did not file any cross appeal.
That's right.
From supplementary list for orders we refer to item 2. First appeal filing number 5636 of 2025.
Passover for the case number.
very higher for the removal of defects. Defect is to the extent of envelope of court fee. You know, also granted us 1 week time for filing response to the same.
आपकी की तरफ से
State.
state हाँ
The-
you have to file your response.
No, I was paying for some further time.
Filing number AP 5636 of 25. How much time do you need?
2 weeks.
The learned counsel for the parties are present. Yes. Counsel for the respondent stated, pray for and is granted time till 13th of August. Correct? 13th of August. By way of last indulgence, to file a response in terms of order dated, the response to the interlocutory application in terms of order dated 1/7/2025. Hold this case on 19th of August in the supplementary case.
That's it. One private respondent is there. Respondent number 1. If possible, let notice be issued to the respondent number 1 so that the matter can be.
अभी तो आपका
तब तो
कोर्ट
मेरी
फीस ही
declaration
नहीं
होगा तब तो।
नहीं ये तो only कोर्ट फीस पर है. कि
आप ही कोर्ट फीस पे लड़ रहे हैं कोर्ट
जी।
फीस पेमेंट करिए अभी नोटिस कर देंगे बिना कोर्ट फीस के नोटिस कोर्ट फीस का डिफेक्ट इग्नोर नहीं कर सकते
From date is for hearing under order 41, rule 11, item 11, second appeal 96 of 2022.
Yes, I do.
Leadership, this matter, partition suit has been decreed by the trial court. Thereafter, the appeal was preferred by the defendant. The appeal has been dismissed, and thereafter the defendant is in second.
Concurrent finding?
Yes,
Concurrent finding.
concurrent finding, and both the parties are brothers. The suit is for partition filed by the plaintiff's sister against his brother.
Only one sister, one brother.
One sister, one brother.
सिस्टर को भी नहीं देना हंस के देंगे कि हार के देंगे ये बताइए
Actually, I have been engaged to argue the case.
That's right. You argue the-
Difficult.
show me the substantial question of
Substantial question of law, leadership would be that the
कहाँ आप
father,
फ्रेम किए होंगे ना
yes,
बताइए कहाँ
F at page 6.
पढ़िए
Whether in view of the fact that no documentary evidence was produced by the plaintiff of any partition between Narayan Dutt and Dharini Datta. Dharini Datta is the father of the parties. And as such, the instance suit for partition without impeding the heirs of Narayan Datta and also bringing within the frame of the suit all the properties belonging to Narayan Datta and Dharini Datta, and as such, the instance suit was bad for non-joinder or also for partial partition. This is one.
Are you serious? अभी तो दो भाई बहन लड़ रहे हैं 50-50 सारे प्रॉपर्टी आ जाएंगे तो आपको कितना मिलेगा 5% एक जीरो चला जाएगा
In leadership, I could fairly concede that this appeal, in fact, in the last occasion, even though I was not very prompt in rightfully approaching to the court. I have read that thing also, the brief. So Vinita Sharma case is there. They have argued on the point that 1954 is the date of death. That is immaterial because subsection 5 of section 6 is very clear to that effect. And Supreme Court has interpreted in
Yes, it's
thereafter
very, very
that, you know, now in first appeal also, if the matter is carried post final decree in first appeal,
Yes, yes.
then also in appellate before this honorable
Yes.
court, that also the share
That
has
is
to be
also
granted.
binding.
That also
There is
binding.
nothing in this case.
So, ladyship, as far as this part is concerned, there is something to be argued, but your lordships, ultimately, your lordships will see my own witness, defendant number 1 and 5, have stated about previous partition, at least of the year 1980.
Or between the two, father and his brother.
Father and brother. And that has been duly taken note of by both the courts. Even though lordship order 41 rule 31, that points of determination has not been framed. That is an error of law, but that could not cause prejudice.
By and large, every
By and
evidence
large.
has been taken into
That's a difficulty, lordship. So it's very difficult to actually
You
put
see,
up a
I'll tell
suspect.
you one thing. I never stop anybody from arguing, but there has to be something to argue. As a counsel, also, you know,
Yes.
when the litigant is there, you are bound to represent him. But these points are not there. Finding बाप बता दीजिए आप. ट्रायल कोर्ट का वो दिखाइए.
Lordship, the trial court findings. Is that
Issue number?
issue number 4 and 5 would be relevant at page 4. At para 4 at page 60, running page 64.
Yes.
The relevant issues would be 3 and 5. 5. Whether the suit is defective for non-joinder of necessary parties, and 4 is that whether they are heirs of recorded tenant Kali Charan Datta, and 5th is whether the plaintiff is entitled to 50%. The learned trial court has in fact granted 1/4 share.
Still, you do not want. Why 1/4 share has been granted?
I mean, that has gone in a very peculiar reasoning that since Hindu Women's Right to Property Act, the share of the mother devolved upon, I mean, she was alive, I mean, she passed away 5 years prior to institution of suit. So, both the courts have held that since that property in view of section 14, she was possessed of and it was her interest, I don't know what there prevailed thereafter, said that in view of that, 1/4 will be the entitlement to the plaintiff. Now thereafter the findings are, ladyship may kindly see para 16 subclause 7. That is that page. Running page 17.
Yes.
Therefore, the plaintiff number 1 herself has deposed so that on calculation the year of death of Dharnidhar Datta, father of the plaintiff defendant, comes as 1954, which is the year of death of the Dharnidhar Datta as per the defense written statement. The Dharnidhar Datta died prior to 1956, prior to commencement of Hindu Succession Act, which came into force in 1756. But this finding is of no consequence because parties remain true. Thereafter, para 70.
The lady
para
has
70
not filed any.
No, she has not filed.
Have you checked that?
I have not checked. I have not checked her.
ये देखिए इस नाम से कोई अपील फाइल हुआ है क्या?
Sandhya Roach.
संध्या रोज. SNDHYA RWG.
fact, if there is a dismissal, that would be a closure of her rights. If there is a notice, at least at the stage of admission, she can appear before lordship and contest. So at the stage of admission, there is no requirement of framing a substantive. Then after para 17 regarding the family partition of 1980, this is very important at page 78.
That's right.
Para 17 subclause 6 at page 81. Therefore, after going through the testimonies of three PWs, including plaintiff number 1 and defendant number DW1 and DW5, it has become clear that they have supported the case of plaintiff regarding family partition of 7/6/1980 after death of Dharnidhar. Datta took possession after the suit property by the defendant and share of plaintiff and calling for salish on 2010. So there was a salish, that is a settlement, to be arrived at between the brother and the sister. Sister demanded half share. Brother said, no, you will not get that. So she refused to sign this. But that was beyond pleading, so that has not been considered by the court. Thereafter, next para talks about whether they are heir of Dharnidhar, but that was not an issue at all.
Five of 24 is court का. There is a
along with supplementary 52 24
Let that appeal be tagged on with the
52 of 24 is attacked in 96 of 22.
क्या 23 तक
हाँ, ये जो दिखा रहा है इसका दिखा रहा है कौन से जजमेंट से अराइज कर रहा है ये सेकंड
5 of 24
हाँ चेक करिए इतना डिलेट तो नहीं हो सकता
civil appeal 7 of 2019
civil appeal 7.
7 of 2019 वो अलग है that is a separate proceeding.
This is 2 of 19.
2 of 19
This is from Partition.
ये दुमका है
कोई और
civil
केस
appeal 7 of 2019 दुमका है
Achha, this is from Partition.
और बताइए क्या क्या है
Thereafter, ladyship at page 92, that is part of para 18's clause 2M. It is granted only 1/4 share. And the reasoning being that since the mother passed away, or the parties, prior to 5 years prior to party, institution of the partition suit, and as such she would be getting interest in view of section 14. Because her husband passed away in 54, so she was having a life interest, and she was having a life interest and post 7/6/56 that came into a state of owning in view of section 14, and that thereafter, I don't know how 1/4 share has been granted.
she claimed half or 1/4
She, the daughter has been 1/4 only.
she claimed what
Half. She claimed half. And thereafter, ladyship, we had put up a case that in view of exhibit 1 and 2, the certain properties in schedule B, even though in the name of somebody else is there. But upon reading of those documents, both the courts have held that these pertain to the family. And the close family member has supported the plaintiff from the side of the other branch. And thereafter the issue number 5 is there. In view of the earlier finding at page 92 has been decided, issue number 5 at page 96. Since that has already been decided earlier, so this issue is accordingly decided as far as the non-joined or necessary parties are concerned. Since that has been dealt with in view of the oral testimonies of PWs and BW1 and 5 of the partition of the 1980, even though no documentary evidence was filed, but in view of the clear admissions by the defendant's own witnesses. And this, even though, Your Lordship, the appellate judgment is absolutely in replica of the fashion and the way, without points of determination being framed, everything was a kind of copy paste. But anyway, Your Lordship, the issue is the prejudice. There has to be a issue question of law going to the root of the matter. Otherwise, I can't raise it just being that the question of law will not be a substantial question. I think ladyship, its appeal has not been prepared. It's up to the ladyship. I think ladyship wants to exercise of even the this one. Then the appellate judgment is absolutely without framing any points of determination.
You can have a smart move. You go for mediation. Are you ready?
Let it be tomorrow. I don't have
Okay.
any instruction that way.
Essay number 96 of 2022. For the learned counsel appearing on behalf of the applicant. This appeal has been filed against the judgment dated 9/5/2022 with the bracket decree signed on 20/5/2022, bracket close, passed by learned Principal District Judge at Pakur in Civil Appeal number 2 of 2019, whereby the First Appellate Court has dismissed the appeal and affirmed the judgment dated 8/1/2019 with the bracket decree signed on 18/1/2019, bracket close, passed by Civil Judge within bracket Senior Division bracket close 1 at Pakur entitled Partition Suit number 6 of 2011. The partition suit fought between one brother and sister has been allowed in favor of the sister who was the plaintiff in the case. And the appeal filed by the sole defendant, the brother, has been dismissed by the learned first appellate. The learned counsel, by referring to the substantial question of law, has in particular referred to substantial question of law number F and has submitted that the father of the plaintiff and the defendant, that there has been no documentary proof with regard to partition between the father of the plaintiff and the defendant on the one hand and his brother, namely Narayan Datta, and the suit was not maintainable without impleading all the years of Narayan Datta and without impleading the properties belonging to Narayan Datta. And therefore the suit was bad for non-joinder of necessary parties. The learned counsel submits that the judgment, this point is based on oral evidence as decided by the learned court, but there is no documentary evidence on record with regard to partition, and therefore a substantial question of law be framed and notice be issued to the respondent. That's it.
Yes.
After hearing the learned counsel for the appellant, this court finds that the plaintiff, being the daughter of Dhanidhar Datta, who had expired in the year 1954, had filed the suit for partition against her full brother Ajit Kumar Datta, claiming half share of the suit property. The suit was contested. And following issues were framed by the learned trial. Para 4 में मिलेगा आपको trial court का judgment. Both the parties produced oral as well as documentary evidences. The learned trial court considered the case of the respective parties and the materials on record, and while deciding issue number 4 as to whether the defendant and the plaintiff are heirs of recorded dead in Kalicharan Datta, considered the said issue while dealing with the death of Dhanidhar Datta, the father of the plaintiff and the defendant, who was found to have expired in the year 1954. When the age of the plaintiff was 7 years and her brother, sole defendant, was 4 years of age. The learned court recorded that Dhanidhar Datta had expired prior to coming into force of Hindu Succession Act in the year 1956, which came into force on 17/6/1956. Then the learned trial court dealt with the point regarding partition/family arrangement on 7/6/1980 after death of Dhanidhar Datta. From paragraph 17 onwards, and ultimately recorded a finding in paragraph 17 within bracket 6 that by going through the testimony of 3 PWs, including the plaintiff himself, and also the defendant number 1 and defendant number 5, and also DW1 and DW5, it was clear that They themselves had supported the case of the plaintiff regarding partition/family arrangement on 7/6/1980 after death of Dhanila Datta and possession with look after of the suit property by the defendant half share. Calling of a salish क्या है?
Salish means settlement with before the panchayats.
Okay. And calling for a salish on 2/7/2010.
The document the punchers had signed and the brother had signed, but not the
Since the witnesses of both the defendants had supported the partition/family arrangement, the finding in this connection was recorded in favor of the plaintiff. The learned, they are governed by Mitakshara. The learned recorded that the learned court recorded that the parties are governed by Mitakshara School of Law, School of Hindu Law, and after considering the materials on record, held that the defendant are the heir of the recorded tenant Kalicharan Datta regarding the suit land/suit property. The plaintiff and the defendant. With regard to however, the learned trial court held that the plaintiff was entitled to 1/4 share instead of half share by virtue of discussions made in paragraph 18, bracket 2, in bracket M. The learned trial court ultimately decided the issue number 4 in favor of the plaintiff by paragraph 20. So far as issue number 5 is concerned, the same was already considered by deciding issue number 4, and it was held that the plaintiff was entitled to 1/4 share. With respect to issue number 1 to 3, they were taken up together. The learned court specifically referred to paragraph, the learned trial court held in paragraph 25 as follows. The issue number 1 to 3 was also decided in favor of the plaintiff. By deciding issue number 6, the learned trial court ultimately held that the plaintiff was entitled to 1/4 share in the ancestral property, that is the suit land. The learned trial court ultimately held that the plaintiff was entitled to 1/4 share and the defendant was entitled to 3/4 share of the scheduled property in Schedule A and B of the plaintiff. The finding, the trial court ordered as follows. The learned first appellate court has has also considered the materials on record and has observed that the crucial issues were issue number 4 and 5, which were framed by the learned trial court. However, the learned first appellate court has also considered every aspect of the matter and dismissed the appeal filed by the defendant, that is the brother of the plaintiff. This court finds that there are concurrent findings in connection with the previous partition, which is based on the evidence of the plaintiff as well as the defendant, and therefore no question of law, much less any substantial question of law, arises with respect to the substantial question of law as pointed out by the learned counsel for the appellant. There is no scope for reappreciation of evidences on record, and no perversity as such has been pointed out in the matter of appreciation of evidences on record, calling for framing any substantial question of law. In such circumstances, the suit has been rightly held to be not barred on account of non-joinder of parties who were Narayan Datta or his descendants, nor can it be said, nor their properties were required to be brought on record for the purposes of partition. This court is not inclined to pronounce anything with respect to other findings, particularly the share allocated to the sister. And it is not clear as to whether the sister has filed any appeal arising out of the same proceedings. However, so far as the arguments of the appellants are concerned, this court does not find any reason to frame substantial question of law and to admit this case. Accordingly, this appeal is hereby dismissed.
Item 12, second appeal 133 of 1023.
This appeal arises out of a judgment passed in partition suit. The approved judgment is against reversal. Trial court dismissed the suit. Lower appellate court allowed the appeal with respect to some of the property for partition. The case is like this. It is case of the plaintiff that Kublal Singh was the common ancestor, having three sons, Bodhan Singh, Bansi Singh and Nathani Singh. Bodhan Singh died in the year 1936 and thereafter within 3 months, Bansi Singh also died. Nathani Singh had only one daughter, Bachi Devi. The plaintiff, the sole plaintiff, Keval Prasad Singh, is son of Bansi Singh, and defendant number 4 and 5 are his brother, Ramavtar Singh and Ramchandra Singh. While Bodhan Singh had 3 sons, Mahavir Singh, Gariban Singh and Amir Chand Singh. Gariban Singh got married in the year 1939. Originally they were belonging to Nalanda district. Gariban Singh in the year 1939 after marriage came to Madhupur at his in-laws house because his father-in-law had only daughter Gauri Devi to whom Gariban Singh was married. And there Gariban Singh started business and earned money. Now the case of the plaintiff is that the parties were joint. It is a joint family property. The contention in the plaint, all over the plaint, entire plaint, that properties are joint family property.
Which property? Property at Madhupur.
Yes,
What is the schedule of the property?
the schedule of the
Property is situated at Madhupur. Trial court का डिग्री का ट्रायल कोर्ट का डिग्री
जी, है। ट्रायल कोर्ट का डिग्री में है अपने कोर्ट का तो प्लेट से दिखा दो all that
आप कौन
land
है डिफेंडेंट है कि प्लेंटिफ है पार्टली अलाउड
yeah I'm defendant
you say that this property is self
yes self approval
which property is what was the finding of the learned trial court
the Garnet trial court
पार्टीशन किस प्रॉपर्टी का किया किस प्रॉपर्टी को छोड़ दिया
item number it is item number 2 3 and 4 with respect to item number 2 3 and 4 it is allowed. All item number 2 is all that homestead land measuring approximately 6 decisions at present worthy from part of closing number such and such Moja Korwa, Islampur, formerly district Patna, and presently it is Nalanda. So 6 dismills of land of Nalanda is item
Property
number
number 5 is existing.
2. All that one sweep mid so line.
The district judge has refused to partition item number 5 by saying that it is not existing,
Yes.
right?
Yes.
So you are not agreed by that.
No.
And with respect to 1, what is the finding with respect to 1?
It is the finding that it is not, it is self-acquired property of variable C.
Self-acquired.
Judge.
On the admission of the parties
Yes.
and evidence that Gariban Singh earned the money for purchasing the aforesaid property came from income of shops which was run by the labor of family members. They are not treated as self-acquired property of Gariban Singh. आप गरीबन सिंह को रिप्रेजेंट कर रहे हैं ना? Fail to prove the claim with respect to Schedule B property. तो इससे भी आपको कोई ग्रीवेंस नहीं है. जो मिला है उससे ग्रीवेंस है. 1, 3 and 4 के बारे में 1, 3 and 4 of Schedule A के बारे में क्या फाइंडिंग है कोर्ट का? ट्रायल कोर्ट का फाइंडिंग क्या है?
Trial.
What was the finding of the trial court?
Issue number 4, 5 and 6 are taken together.
Page number?
Page,
The trial court found that there was no nucleus.
yes. And has given the reason. The reason is,
Where is the reason that there is no nucleus?
reason, paragraph 90, page 91, if I am correct, it is page 91.
Paragraph बताइए.
Paragraph 90. Page
Internal
34.
page 32.
Yes. Page 34, it appears. Considering the aforesaid fact and
आप
on
उसके पहले पढ़िए. पैरा 33 भी पढ़िए. ये उसका previous paragraph.
the learned lawyer opinion on behalf of the plaintiff submit that the descendant of Lal Singh are joined. Both the
नहीं
parties
नहीं
are,
कहाँ से पढ़े थे?
it is at page 33.
33. कहाँ से पढ़े थे सर? ऊपर नीचे कोई तो बताएंगे.
Paragraph 18.
18 तो इसमें नहीं
Page
लिखा.
33 में para 18.
पैरा 18 शुरू हो रहा है.
जी, learned lawyer.
Appellate court. Title suit.
And title suit.
नहीं टाइटल सूट का तो हमको इसमें पैरा 18 दिखी.
Para 17 शुरू होता है.
पैरा 18 तो 23 में. इंटरनल पेज 23 में.
जी.
है ना? बड़ी
The lawyer agreeing on behalf of the plaintiff submits that the descendant of Lal Singh are joint. Both the parties are still joint. They are entitled to 1/6 share in the suit property. The lawyer of the plaintiff also submits that the plaintiff has succeeded in proving that the property are still joint by his oral and documentary evidence. Whereas the lawyer for the defendant first party submitted that after death of Kublal Singh, all the three sons were separated in mason business. They were poor and they have only 6 dismills of land, and there is no joint family between sons of Kublal Singh, which shows from the evidence and documents filed by both the parties. Plaintiff has not filed any sheet of paper to show that they were joint and there exists joint family between grandson of Kublal Singh, and Kublal Singh has sufficient income to purchase the suit property. Gariban Singh came at Madhupur after marriage and started living at Sasural and business, and out of his income purchased properties at Madhupur and also some properties at Malik Sarai. Defendants were given only permissible possession to reside in portion of Madhupur only on sympathetical ground at Lord Sinha Road. Considering the aforesaid facts and on perusal of the oral and documentary evidence and taken into account the argument advanced on behalf of the parties of the suit, I would like to deal with some points before reaching to any conclusion with regard to the issues. First, plaintiff has filed and relied on Exhibit 1, which is Jimmanama given to Gariban Singh. This document is dated 1/5/1989 prior to filing of the suit. From plain reading of this document, in the last line of first paragraph, it is written that the property of Gandhi Chowk, Madhupur is of Gauri Devi and Gariban Singh. Gauri Devi is wife of Gariban Singh. It does not show that this is joint property. The document, which is carbon copy only filed by the plaintiff, it does not mean that the property is joint property. Plaintiff has filed municipal receipt, that is Exhibit 222D, which also shows that the property of holding number 13 is in the name of Gauri Devi till filing of this suit and after filing of this suit. Plaintiff has stressed that tax was paid by him, but most of the receipts are of after filing of the suit and name of Gauri Devi is mentioned. In extra word paid by KP Singh and Ramotar Singh is mentioned, which is not necessary for writing this word. Moreover, Gauri Devi died in the year 1991 and this suit has been filed on 19/1/1993. Plaintiff has also filed rent receipts, that is Exhibit 3 to Exhibit 3B. Exhibit 3 is of the year 1994. Name of recorded tenant is Gauri Devi. Exhibit 3A is dated 17/6/94. Name of recorded tenant is Rampyari Devi, and Exhibit 3B is of the year 2000. This Rampyari Devi is the stepmother-in-law of Gariban Singh. All the 3 exhibits are after filing of the suit and after 4 compromise obtained. In the suit at the initial stage, a compromise was entered into said to have been entered into between the parties, and that compromise was challenged before the appellate court, and that decree was set aside. Exhibit 6 to 6C are sale deeds. Exhibit 6 is sale deed number such and such of the 1989 in favor of Gauri Devi and executed by Rampyari Devi in favor of stepdaughter and wife of Gariban Singh. Exhibit 6A is also a sale deed number such and such of the year 1989 executed by Rampyari in favor of son-in-law Gariban Singh. Exhibit 6B is certified copy of sale deed dated 24/8/1992. This sale deed was executed by Amir Chand Singh and Dayanand Singh, that is defendant number 1 and 2 in favor of Sakuntala Kumari. From perusal of Exhibit B, it transpired that the property mentioned in Exhibit A,
Appellate court क्या किया? Appellate court का finding.
the appellate court has mainly relied upon that compromise which was said to have been entered into between the parties, which was set aside. The decree has been set aside by the lower appellate court and the matter was remanded back, and relying on that has decreed the suit with respect to item number 4, 5 2, 3 and 4.
You read para 21 of the appellate court judgment.
Para 21. Regarding the property mentioned in item number 3, 2, 3 and 4 of the Schedule A of the plan, the document are clearly established that item number 2 is in the name of Gariban Singh, Amir Chand Singh, Mahavir Singh, one share equally, and Keval Singh, Ramotar Singh, Ramchandar Singh, one share equally. On this property, there is no dispute. For the property mentioned in item number 3, as per document, the aforesaid property is purchased in the name of Gauri Devi, wife of Gariban Singh, Exhibit C by 3. Item number 4 is property has been purchased by two salees. First sale deed in the name of Gauri Devi, wife of Gariban Singh, and second sale deed in the name of Gariban Singh. So I have no objection with respect to item number 2 also. It is the property of Act Nalanda, which was in the name of Kublal Singh. It has been contended on behalf of contesting defendant respondent that nowhere in the aforesaid sale deed it has been described that the aforesaid property purchased from joint nucleus of the family or anything invested by the other member of the family in the purchase of the aforesaid property. On perusal of the aforesaid exhibit 1, I find exhibits, I find that it has not been mentioned in the content of the aforesaid exhibits that any other member of the family invested anything in purchase of the aforesaid property. Although on behalf of the appellant, photocopy of an indenture of the property mentioned in item number 3, and it is pointed out that this property has been purchased on behalf of Gariban Singh by Ramotar Singh, and Ramotar Singh had been paid the money through bank draft. Since this document is not exhibited, therefore argument of the plaintiff appellant cannot be relied. Now the question arises whether the aforesaid property may be treated as self-acquired property of Gariban Singh, as stated above the proceeding in the preceding paragraph. It has been established that Gariban Singh was a member of joint Hindu family, and he and the member of joint family had joint labor in running of sweetmeat shop and tea stall business of the Gariban Singh, and I do not find any evidence that Gariban Singh had any other source of income except this law. In the 6th edition of Men's Hindu Law and Usage, page 7 to 7, it has been described. It is now well settled that when the member of joint family by their joint labor or in their joint business acquire property, that property in absence of clear indication of any contrary intention would be owned by them.
तो इसमें क्या गड़बड़ है? तो पूरा डिस्कस करके होल्ड कर दिया है. It is a joint family property, which is primarily based on appreciation of material.
No. Court of Appeal law has not considered the reasoning that has been assigned by the trial court. I may be again allowed to read that finding of the learned trial court. I mentioned, I have stated it is at paragraph, page 26, internal page 26 of the trial court. 25 से आप पढ़ कर रखिए सर. 25 also filed and received such and such exhibit 6 I had paragraph number page 25 paragraph 3 exhibit 6 to 6 are sale deeds. 6 is sale deed number such and such in favor of Gauri Devi executed by Ram Pyari in favor of his stepdaughter and wife of Gariban Singh. Exhibit 6A is also a sale deed number 1304 dated 1989 executed by Ram Pyari in favor of son-in-law Gariban Singh. Exhibit 6B is certified copy of the sale deed dated 24/8/82, the sale deed was executed by Amir Chand Singh and Dayanand Singh, the defendant number 1 and 2 in favor of Secretary. From perusal of Exhibit 6B, it transpired that the property mentioned in Exhibit A is in the name of Garinder Singh, has been sold by defendant number 1 and 2, his brother and nephew, after death of Garinder Singh. Exhibit 6C is also a certified copy of the sale deed dated 24/8/1992, executed by Amir Chand Singh and Dayanand Singh as heir and successor of Garinder Singh. Exhibit 6C is also sale deed dated 24/8/92.
आप ऐसे पढ़ेंगे तो क्या ही होगा सेकंड अपील?
जी, तो एक लाइन और आगे बढ़ जाते हैं. On perusal of entire sale deed, it transpired that all the sale deeds are before filing of the suit and executed by or executed in favor of defendant first party or their ancestor. On perusal of Exhibit 6 and 6A, it transpired that it is mentioned that it is exclusive property of the executant. Surprisingly, plaintiff, who is an advocate, has not claimed or filed any suit for cancellation of the sale deed or any objection has been made. Only by filing this document it cannot infer that properties are joint property. Exhibit A is Khadian slip, exclusive name of Gariban Singh. The parentage mentioned as Kublal Singh of Khada number 88 of Islampur area 50 Dismissal. Only mentioning of name of father is not going to show that the document is full. Plaintiff himself relied upon this document. On perusal of Exhibit 8A and is for 6 Dismissal Islampur, which is only appear to be joint family. I have also no objection to that. In the Rayat column, it is mentioned Gariban Singh, Mahavir Singh, Amir Singh, Putra Bandhan Singh, एक हिस्सा बराबर है.
Which portion is held to be a joint family property?
So these documents.
Which portion? आप एक बार पेज नंबर बताइए तो आप कहाँ पढ़ रहे हैं?
Appellate को.
हाँ, वो पेज नंबर अभी हम देख ही रहे थे मतलब मिस.
Page number, internal page of your Appellate code, page 30.
1.3 तो फाइंडिंग नहीं है ना?
Then 30. 30.
Yes. आप इसको पढ़िए. On the perusal of the aforesaid exhibits, I find पढ़िए जरा. पढ़िए on perusal of the aforesaid exhibits जो advocate का बारे में लिखा.
On perusal of Exhibit 8 in Islam को यही पढ़ा. Advocate has not claimed or filed any objection, sale deed or any objection has been made. Only by filing document it cannot infer that property or joint property. Exhibit 8 is Khadian slip, exclusive name of Gariban Singh. The parentage mentioned Kublal Singh, Khata number 88 of Islampur area 50 Dismissal. Only mentioning name of father of whom is not going to show that document is forced. Plaintiff himself relied upon this document. On perusal of Exhibit 8A, it is of 6 Dismissal of Islampur, which only appears to be joint ancestral property. In the Rayat column, it is mentioned Gariban Singh एवं महावीर सिंह एवं अमीर सिंह पुत्र बंधन सिंह एक हिस्सा बराबर और केवल सिंह और रामोतार सिंह और चंद्र सिंह पिता बंसी सिंह एक हिस्सा बराबर. It shows that defendant first party got half share and plaintiff and defendant second party got half share out of total 6 Dismissal. The certified copy has been filed by the plaintiff himself and obtained on 1/10/1992 before filing of the present suit. So there is strong presumption that there was a clear partition between the descendant of Kublal Singh entry in Khatian is conclusive proof of the status of the parties. Exhibit 8B is also a continuous Khatian of 10 to 9.
इतना तो आपका evidence discuss किया है to say that it was a joint property. So what is the error in this judgment?
कुछ डिस्कशन नहीं है, सिर्फ क्या डिस्कशन है ये हम पढ़ दे रहे हैं फिर पेज 75 में. In the present case, although it has not been mentioned in the aforesaid sale deed that other family members had invested their money for the purchase of aforesaid property, but it is clear from evidence that business was jointly run. Although the contesting defendant Dayanand Singh had denied any investment of the plaintiff at supporting defendant in the purchase of the aforesaid property, but his cross-examination he admitted in paragraph 108 of his cross-examination that all the properties of Madhupur and Islampur are joint. यहीं पे हिच है, यहीं पे फंस जाता है.
You see, once there is a nucleus in the sense that the shop was jointly run. There is a finding that the shop was jointly run.
It is also case of the plaintiff. That's first after marriage in the year 1939, Gariban Singh came and settled at Madhupur and he started business with his father-in-law, and he opened a sweetmeat shop and a tea stall. Thereafter, to accommodate, they are not the full brother, plaintiffs are. To accommodate them, because there was no property, only a 6 dismills of land in which house was there. So to accommodate them, allow them to reside in the house and settle them in other business, the plaintiff became a lawyer. He is a practicing lawyer at Khandwa. And but there is no nucleus. There is no evidence. If
The shop was being jointly run.
No, they were working as a worker.
कहाँ पर क्या evidence है? नौकरी करते थे वो लोग.
हाँ, उनको adjust किए हुए
सैलरी
थे.
देते थे.
हाँ,
कहाँ दिखाइए ना, evidence दिखाइए.
plaintiff,
Evidence दिखाइए कि अपने भाई लोग को आप सैलरी देते.
they were not full brother.
Whatever, show me that they were getting salary.
Kublal Singh died something.
You show me some evidence that they were being paid salary.
So, Bodhan Singh.
नौकरी करते थे तो सैलरी मिलता होगा ना, कुछ तो पैसा मिलता होगा ना.
तो हम
क्या एविडेंस है? ओरल एविडेंस ही दिखा दीजिए.
हाँ, हम तो इलिटरेट थे, लेकिन
आप तुरंत आप लोग इलिटरेट हो जाते हैं सवाल पूछने से.
प्लेंटिफ इज लिटरेट. प्लेंटिफ
आप लिटरेट है ना.
हाँ, तो प्लेंटिफ जो
लिटिगेंट इलिटरेट होने से वकील साहब ज्यादा लिटरेट हो जाते हैं.
तो प्लेंटिफ इज ए प्रैक्टिसिंग एडवोकेट.
तो क्या करें हम लोग?
Adduced any evidence that he has contributed this much of money
Need not.
in
You see now the
and
finding
the document says that it is only in the name of Gariban Singh and in the name of his wife. And his wife has purchased some property from her stepmother. So how it will come in common hodgepodge? It can't be. Then only reliance has been placed on the statement at paragraph 108. पैराग्राफ 8 में क्या लिखा है? क्रॉस में मधुपुर की
राम अवतार सिंह कौन है?
राम अवतार सिंह is defendant number 4. He is brother of plaintiff, full brother of plaintiff.
With respect to item number 3, it has been pointed out that the property has been purchased on behalf of Gariban Singh by Ram Avtar Singh. And Ram Avtar Singh had paid the money through bank draft.
कोई एविडेंस नहीं
Deed में लिखा हुआ है ना?
नहीं
फिर क्या?
कोई एविडेंस नहीं
और कौन सा एविडेंस लेके आएंगे?
अब कह रहे हैं एक
बैंक ड्राफ्ट कहाँ से लेके आएंगे?
हाँ?
कहाँ से लेके आएंगे बैंक ड्राफ्ट? If the manner in which the consideration is paid is recorded in the sale deed, what other evidence is required?
नहीं हम डॉक्यूमेंट देखेंगे तब
कौन सा document?
नहीं उससे भी
हम नहीं जानते हैं, आपका तो ऐसा कुछ भी नहीं है।
हमारा प्ली है कि तो हमारा परचेज है और एक लास्ट कंक्लूजन जो है पैराग्राफ में underrating cross examination that all the property of Madhupur and Islampur are joint. The admission supports the claim of the plaintiff. One thing is also clearing that the aforesaid compromise exhibit 22 has not been nullified by the London District Judge Devkar in title appeal number 9. In that compromise petition, Amir Chand Singh and Dayanand Singh, son of Amir Chand Singh, admitted the claim of the plaintiff. That admission is against interest of Amir Chand Singh. So this compromise is nullified. It is set aside. It is set aside by the decree by the lower appellate court
Which decree?
on appeal.
Which decree?
Earlier, the suit was at the initial when the suit was filed at the initial stage.
When was it set aside?
I may be. It is set aside by judgment. Trial court's judgment, page 28. Exhibit 18 is certified copy of judgment of title appeal number 9 of 2003, passed by the then learned judge Sri Harish Chandra Mishra by judgment dated 4/3/2004. The learned court has set aside the judgment dated 23/1998 obtained on basis of compromise decree and learned district judge observed in paragraph 11 that the court below has passed illegal order without any application of judicial mind and pleased to set aside and remanded the case for fresh trial. Thereafter, this judgment was the judgment of the trial court came into existence, against which the appeal was filed and the appellate court has considered. So, how the compromise was illegal, that has also been dealt with.
That has not been considered by the appellate court.
No, at no point of time, at no place. Exhibit 22 is joint compromise application which is filed in this court on 4/3/1998. Plaintiff has given much reliance on the application that according to compromise petition, plaintiff is entitled for share. On perusal of compromise petition, we transferred that it bears LTI of Amir Chand Singh, defendant number 1, signature of Om Prakash Singh, defendant number 3, and plaintiff Keval Singh and defendant number plaintiff Keval Singh, and defendant second party Ramchand Singh and Ram Avtar Singh. On perusal of this document, which is filed by the plaintiff, which bears the signature of learned lawyer, Mr. Pradeep Kumar Sinha, advocate for plaintiff, on perusal of case record, it transpired that the written statement filed on behalf of the defendant first party, that is Amir Chand Singh and Om Prakash Singh, surprisingly on the written statement dated
अच्छा बताइए आपका substantial question of law क्या है?
so substantial question of law. दो एडिशनल के हम ट्रैक किए हैं और
चालीस 50 substantial question of law बना दीजिए. Yes. शोभा देता है आपको.
गलती है
गलती क्या है? बताइए. क्या तरीका है आप लोग का? फर्स्ट अपील की तरह सेकंड अपील बनाते हैं और बहस भी वैसे ही करते हैं.
हम बहुत सेकंड अपील बनाए हम नहीं
बनाए नहीं थे तो ये सप्लीमेंट्री एफिडेविट तो आप ही के कहने से बना होगा ना.
बात नहीं हमको पता है. हमें दो फ्रेम किए हैं.
ये एक सप्लीमेंट्री बना है, उसका अलावा भी आपको कुछ डालना है इसमें.
हम दो तो सबसे क्वेश्चन ऑफ फ्रेम किए हैं.
This compromise was set aside.
Yes.
Exhibit by exhibit.
Exhibit 22. Exhibit 18, sorry. Exhibit 18 is the copy of the judgment of title appeal number 9 of 2003.
Okay, second appeal number 133 of 2023. Heard the learned counsel appealing on behalf of the appellant. The learned counsel for the appellant has submitted that the partition suit was dismissed and the learned first appellate court has directed for partition with respect to item number 2, 3 and 4 of Schedule A property, and has held that the plaintiff is entitled to 1/6 share. The learned counsel has submitted that the learned first appellate court has heavily relied upon the compromise entered earlier to come to a conclusion that there was a joint family and there was a nucleus in the joint family, but the same was set aside, but the compromise itself was set aside by the Exhibit 18. He has also submitted that the learned first appellate court has not made the reasons. इतना ही बहुत होगा क्या? This should be sufficient compromise करने के लिए. क्या? इसमें क्या करें?
Requirement है order 41 rule 31. Wow.
The learned
While upsetting
counsel has also submitted that while upsetting the judgment of the learned trial court, the learned first appellate court has not met with the reasons recorded by the trial court, while who had refused partition with respect to all the parties. This appeal is admitted on following substantial questions. Whether the findings of the learned first appellate court is vitiated due to non-meeting of the reasons of the trial court while upsetting the findings in connection with properties mentioned in item number Roman 2, Roman 3, Roman 4 of Schedule A of the plate. A है ना? Whether the learned first appellate court committed error while relying upon the compromise which is alleged to have been set aside by the Exhibit 18 to come to findings in order to partly allow the appeal. If you notice, किसको जाएगा? How many respondents? To the respondents for which requisites under ordinary process be filed within a period of 15 days from today. Post this case on 29th of October, awaiting service to court.
23 पार्टी हैं 3 सप्ताह का केस है
3 दिन का दे देंगे. मुंशी जी आपके इतने इनएफिशिएंट तो नहीं है. 2 हफ्ता और आपको फॉर्म ही तो फाइल करना है. एडिट हुआ है.
Item 13, second bit 207 of 2023.
This one.
This is a case for reversal. It's a reversal. So the case is of the plaintiff, then short of that. Plaintiff and defendant by caste of Oraon, governed by Oraon customary law. Geeta Oraon, wife of a Pali Oraon, purchased the land by her Sridhan got gift by her maternal parent excluded by the income of the joint family property under RS Khata number 2002, Khata Kevat number 10/3, plot number 673, area 30, Dismissal, Thana 212, village is Samrao.
It is a judgment of reversal. She was
It's
who
a
was
reversal.
claiming partition?
Actually, her son, the younger son, was claiming the partition, and first he gone for the trial court. She purchased the land of 30 dismal, and the dispute arises in two brothers. After that, he went for the partition suit, 2011. In the year the 2011, and got the partition suit 50-50.
The lady was also a party in the suit.
No, the lady is a mother.
She must
she,
have
she
expired.
died. She died. After the death, the two brothers are fighting that battle year. So younger brother went to the trial court, and 2011, and he filed a partition suit. And whereas their 50-50%, they have given the court.
Why that
Again,
first appellate court has reversed?
First appellate court has reversed that the after death of the that defendant, the sons are coming there after the 4 years lapse of the judgment. That was in 2014, and they have come in 2019. That my father.
Judgment. I don't get it.
That the trial court judgment.
Trial court judgment is 2015.
2015, and appeal was coming from 19. After the.
It has been held as
After 4
barred
years.
by limitation.
Barred by
It
limitation.
has been held to be barred by limitation.
Yes.
No, let us see. It has been held to be.
Barred by limitation. They are telling, the sons are telling, my father has not got the summon and something as a not knowledge, but we peruse through the records that his father was appeared there, that the defendant appeared there, but he has not given his any statement. He filed the Vakalatama and everything. Shall we read first one? Trial court or?
No, appellate court. Where do you say that the appellate court has held that the appeal is barred by limitation?
Actually, they no. Appeal. They granted the appeal. In the appellate court made two issues. First, that let's see the page number. Page number 15 this we see the action number 1, page number 16, para number 13.
Yes.
After having seen the pleading of the parties, the memo of the appeal filed by the appellant plaintiff, the reply of the respondent to the memo of appeal, the recorded of learned court, partition suit number 173 of 2011, the judgment and the following are point determination in the appeal, whether someone was served to the Ramesh Topo through Najarat, whether Ramesh Topo appeared in the court and rightly debarred from filing a written statement. Second one, whether a suit for the partition is only one property is maintainable to the exclusion of other property. Now, the first issue, in the first issue, actually they are claiming they don't have a knowledge of that suit, but the court hold that in issue number 1, in next from the perusal, issue number 1,
The appellate court has held that the partial partition is not maintainable.
हाँ, but the thing is that this property, it's coming for the self-accord property of her mother, his
You
mother.
see, the party will be at liberty if so desire to file fresh partition suit, and the judgment of partition suit number 173 in civil appeal number 65 of 19
Yes,
will not operate as res judicata.
yes.
फ्रेश सूट फाइल कर दीजिए, क्या करना है?
नहीं, इसमें already they have given that ये this हम इसको अभी explain कर देते हैं. The property schedule, the property इसी में ही है. First of all, there is no dispute in the schedule of the property.
Yes.
That is
ये partition suit number 173. You see, they simply say that you can go and file a fresh suit. What's
Why?
the big deal about it?
नहीं, already तो 50-50 हो ही गया है. मेरा ये कहना है, this property is the self-accord property of her mother. That is another thing, and they are telling or they have not disclosed anything in the trial court. Now the defendant is coming in the appellate court, and defendant not coming. Defendant's sons are coming and telling that they have another property, that is an ancestor property, that that is not entered.
Defendant did not come to the appellate court.
No. Defendant died on 2018. And they are making for the limitation that they don't have knowledge. One, the first issue was proof that they are telling lie. And actually then, please see the, एक बार हम पढ़ लेते हैं, हम इसका शॉर्ट एक ये बता देते हैं, है ना? उसके बाद क्लियर हो जाएगा हमारा. 1947, the
It was an ex parte judgment.
हाँ, ex parte किस समय वकालतनामा, he has filed the वकालतनामा, he has given ample opportunity to file a written statement.
Who filed wakalatnama?
Defendant.
They filed wakalatnama.
Yeah. Yes.
Read
In appellate court, that judgment is there.
Read para 3.
Yes.
Para 3 of the trial court. समन प्राप्त होने पर
हाँ, एक मिनट. उसके बाद हम appellate वाला भी ये करते हैं.
निर्धारित अवधि में जवाब नहीं दाखिल.
समन प्राप्त होने के बाद इस वाद में प्रतिवादी एक जो है न्यायालय में उपस्थित हुई, परंतु निर्धारित अवधि में जवाब नहीं दाखिल किए जाने के कारण आदेश 25/4/2012 को उन्हें लिखित अभिकथन दाखिल करने से वंचित कर दिया गया. मतलब कि they have already appeared there, they have got the opportunity to file the written statement, whatever they have objection. And after that, 24th of 2nd 2012, ex parte was declared for the written statement only. उसके बाद न्यायालय के समक्ष इस वाद का निराकरण हेतु मुख्य विवाद बिंदु यह है कि क्या प्रतिवादित भूमि से आधा अंश प्राप्त करने के अधिकारी है. अब यहाँ अपीलेट कोर्ट में भी यहाँ पर हम बता दें. Para number 15 of the judgment of the appellate court. 14. From the perusal of the lower court record, it is clear that the service report of the summons sent through Najarat shows that there is a signature of the Rimish Topo on the Baklatama, there is a LTI, there is no other document in record to show that the signature of the service report of the summons is of the Rimish Topo. There is no reason to be disbelieved either. Also, there is no rule that a person who writes cannot put LTI. Another significant point is that notice sent through post with acknowledgement was returned. The acknowledgement is not very clear, but it is read either return or refuse. What is the point is that if it is returned, then postal service was not proper. If it is refused, then postal service is deemed to be have taken place. It is held that there is a proper service and the defendant Rimis Toko appear in the lower court. That is the defendant. The defendant did not file written statement. He was barred from the filing written statement. Thus, on the perusal of these, it is held that the service was proper and the defendant was debarred from the filing written statement. This point is decided in the favor of the respondent. अब हम ये बताएं इसमें कि
पार्शियल पार्टीशन कैसे होगा आपका?
पार्शियल पार्टीशन नहीं होगा इसमें, वही तो बात है.
There are no other properties.
No.
No, you have yourself said that there was some property which was already partitioned.
No, this is the self-assured property of her mother. दो भाई का है, इसमें बहुत सारे several judgments are there कि ancestral property that is coming from the 4 generations, that is called ancestral properties are this. And ये वाला जो है mother का self-assured property है. तो मतलब उसमें क्या
Mother के death के बाद वो ancestral property नहीं बनेगा.
नहीं, ये डायरेक्ट आ रहा है, सक्सेशन में होगा.
Succession में.
हाँ, सक्सेशन में आ रहा है. तो इसमें ये क्या है, इसमें है कि अगर इसको अगर एनी ऑब्जेक्शन बस गया, he has got the opportunity, he is now ना dependent also not there. Limitation point पर हम लोग अगर आते हैं इसमें भी,
देखिए second appeal number 207 of 2023. The Learned Counsel for the applicant has submitted that the suit for partition was decreed and the defendant, after the defendant was debarred from filing written statement, the Learned First Appellate Court held that the service was proper and the defendant was debarred from filing written statement and decided the issue in favor of the plaintiff who was respondent before the First Appellate Court. She submits that in spite of the aforesaid, the Learned First Appellate Court held that the suit for held that the suit was not maintainable and that the suit for partial partition was not could not be maintained. The Learned First Appellate Court also observed that the party will be at liberty, if so desired, to file fresh partition suit, and the judgment will not operate as res judicata. The Learned Counsel has submitted that the property was not co-pastoral property. Rather, the property was standing in the name of mother of the plaintiff and the defendant, and the same was required to be partitioned half and half. Which was done by the Learned Trial Court. कौन सा substantial question of law है आपका?
page number 6. Whether the learned lower court has really failed to settle the preposition of the law that if the defendant are suppressing the fact.
नहीं. Roman 6.
Plots added in the appeal are which source the parties get from. they have not disclosed that. An ancestral property of the nature and other properties cannot be blended with the ancestral property in the partition suit, as referred in the Supreme Court decision. I'm giving judgment.
Roman 8 कर दें? Roman 8.
जी.
Roman 8.
An ancestral property is always an ancestral property unless it gets divided among the existing co-partners, and the suit land is self-purchased by the Gita Urao, which cannot be counted an ancestral property of the parties, where the purchaser is the absolute owner of the party.
This appeal is admitted for hearing on the following substantial question of law. Whether the property
ये सर्वनाम वाला जजमेंट
कौन सी सर्वनाम है?
ये 9 का है, 9 में है वो 4th generation वाला जो था, 4th generation of the male lineage is called ancestral property, which is not here in the case.
Whether the property involved in the present case could be termed as ancestral property. And whether the impugned, whether the first appellate court was justified in holding the suit as not maintainable by alleging that the suit was for partial partition. Thus, you should notice for records.
ये मेरा फर्स्ट सेकंड अपील था, समझ ही नहीं आ रहा था किधर से करें. Thank you, my lord. बहुत कॉपरेट किया और कुछ गड़बड़ किया मत.
तो एक डेट दे दीजिए प्लीज. आपको एक और केस में दिए ना डेट 29 अक्टूबर.
कितना दिन का रहेगी?
15 दिन में आप क्या बोलते हैं
नोटिस,
ऑर्डिनरी प्रोसेस का नोटिस पर on all the respondents. सब झारखंड के?
हाँ.
For hearing item 14, second appeal 352 of 2016.
What is the substantial question of law?
Order dated 23rd September 2019. Substantial question of whether in view of section 31 the specific legal effect unless granted, the said deed is declared null and void by a court of competent jurisdiction. It shall not be deemed to be cancelled by the deed of cancellations, and only the executed if the deed is not
Where
declared.
is the respondent? The sale deed was not under challenge.
No, madam. Said deed was not a specific under challenge. He says he declared null and void, but no date, nothing was given.
No date. आखिर
No
कोई
date.
deed को तो set aside किया होगा ना, तभी ऐसा substantial question
हाँ,
of law.
तो फिर भी उसको सेट सेट किए. This judgment against the reversal, मारो the learned trial court मारो they dismissed the suit. We are the plaintiff, we are defendants मारो, they are the plaintiffs suit मारो. On the ground that the deed was not brought, the records मारो that was challenged, and suit was also the time barred by limitation.
Where is the trial court decree?
Trial court decree मारो page. Paragraph 13 on words मारो. Trial court judgment page 45 मारो. Paragraph 12 मारो.
the relief break for in the trial?
Was the relief, my lord, was the suit for the declaration of right title and interest and order dated.
ये तो है null and void तो मांगा है.
बस खाली null and void मांगा है, but not specific. वही
है तो salary number 1720 of 96.
नहीं मांगा है.
डिक्री में दिख रहा है हमको.
प्लेट देखा जाएगा हुजूर.
ये डिक्री नहीं देखे.
नहीं जो प्लेट जो है प्लेट ना.
प्लेट में डिक्री में पूरा रिलीफ कोटेड होता है. कोटेड होता है ना. अब देखिए आप ही का पेज नंबर 55 खोलिए. इसीलिए डिक्री खोजते हैं. नहीं डिक्री.
The right title for the suit declared in favor of the plaintiff that the salaried number such and such executed by defendant number 1.
वो सच एंड सच जो आप बोल रहे हैं ना वही है.
हाँ वही लेकिन एक बार आपको देखा जाएगा हुजूर का
क्या देखें.
प्लेट देखा जाएगा. प्लेट एक बार खाली प्लेट देखा जाएगा.
है तो प्लेन. हाँ बताइए क्या करें हम आप.
मेरे पास जो प्लेट है हुजूर
भाई आपके प्लेन से तो हम नहीं चल सकते ना.
नहीं चल सकते.
अमेंडमेंट आके हुआ है.
अमेंडमेंट आता है.
यस 16/1/2010 का अमेंडमेंट हुआ. आपको नहीं पता है.
अमेंडमेंट के बाद
तो ये तो गलत था. सब्सटेंशियल क्वेश्चन ऑफ लॉ बना लिए. हो गया बात खत्म. हम डिसमिस कर देंगे इसे.
एक और चीज है हुजूर, ये चीज और अगर
बताइए.
तो दूसरा है हुजूर तो जो जजमेंट जिसको which was under challenge decree sorry CLD which was under challenge that has not been produced by the plaintiff from the record man. Therefore the suit was dismissed.
This was not exhibited.
Not exhibited by the plaintiff. Never brought in the court man. Trial court का जजमेंट पर
थोड़ा सोच के बोला करिए.
हाँ जो तो डिफेंडेंट का अपना लाइन है उसमें एक्टिविटी मार्क हुआ है. प्लेंटिफ ने बोला
उससे क्या फर्क होगा. डिफेंडेंट प्रोड्यूस करेगा. इट इज नॉट अ पार्ट ऑफ द रिकॉर्ड.
एक्चुअली पार्ट ऑफ द रिकॉर्ड.
क्या जरूरत है प्लेंटिफ को प्रोड्यूस करने का. डिफेंडेंट अपने प्रोड्यूस कर रहा है.
जो डॉक्यूमेंट अंडर चैलेंज अगर करते भी हो तो उसको तो लाना होगा. उसको डॉक्यूमेंट को
क्या जरूरत है. डिफेंडेंट अगर रिकॉर्ड पे ला दिया है बात खत्म है.
उसको प्लेंटिफ को अपना केस खड़ा करना हो. जो डिफेंडेंट का विटनेस है
आपने तो डॉक्यूमेंट एग्जिबिट कर दिया
उसको
ना.
स्ट्रांग नहीं करा.
भाई आपने एग्जिबिट कर दिया विदाउट ऑब्जेक्शन. मार्क हो गया. बात खत्म. अब क्या बचा उसमें. क्यों एग्जिबिट किया आप अपना डॉक्यूमेंट. आप ही का डॉक्यूमेंट है ना.
When you part of the mistake on part of the
मिस्टेक.
defendant.
Mistake.
That
It was not required to be exhibited. You see that came on record for the first time after the filing of the written statement और उसके बाद हो गया. चलिए कल कर लीजिए. आप रिकॉर्ड देख लीजिए. ये बहस आपका चलने वाला नहीं है. ओके.
एक चीज और है जो टाइम बार की लिमिटेशन भी है.
क्या चीज टाइम बाद.
सूट
कब का सेल लीजिए.
1996 का है. सूट फाइल किए हैं हम 2002 में. और ये प्लेंटिफ अपना एविडेंस में PWC who examined as the PW5 they deposed man on his evidence he had knowledge man. His findings are to come paragraph 13 of the trial court judgment man. पेज 8 देखा जाएगा हुजूर.
देखिए जो चीज का आपका
ट्रायल कोर्ट जजमेंट का पेज 8 देखा जाएगा.
जजमेंट ऑफ रिवर्सल है।
हाँ, जजमेंट ऑफ रिवर्सल।
एपलेट कोर्ट ने क्या किया है लिमिटेशन पर?
एपलेट कोर्ट का फाइंडिंग paragraph 43 में बोले हैं उसमें not got by communication।
डेट ऑफ नॉलेज पे गया है।
नहीं,
Date of
इसी-
knowledge।
हाँ, डेट ऑफ नॉलेज, लेकिन इसको ये अपना एविडेंस में बोले तो उनके P-W-5 की उनको नॉलेज में था।
उतना नहीं चलेगा ना।
नहीं, वो तो
उतना नहीं
जो
आपसे-
इनका एविडेंस तो कंसीडर करना होगा और जो पॉइंट ऑफ द लिमिटेशन।
आपने जो यहाँ पर जो फॉर्मुलेट हुआ है उतना ही देखेंगे ना।
उसके लिए तो जो उनको लिबर्टी है और जो हम तो बाद में उसको कर सकते हैं।
कर तो आप सुप्रीम कोर्ट में भी सकते
हम लिमिटेशन के लिए तो कंसीडर कर सकते हैं।
हैं। सेकेंड हाफ में आप आइए, थोड़ा रिकॉर्ड देख लीजिए। अभी हम लोग वो एक फर्स्ट अपील हम लोग का हियरिंग कंटिन्यूटी में है, उसके बाद 15 मिनट देखेंगे।
लिमिटेशन पे एक सब्सटेंशियल क्वेश्चन ऑफ द फील्ड हो सकता है।
हो तो कुछ भी सकता है,
क्योंकि है
होने का तो
उसमें
कोई
फाइंडिंग
वेयर इज द रेस्पोंडेंट?
रिस्पोंडेंट एपीएल से नहीं किए हैं, उनका नाम एपीएल नहीं कर रहा है।
आपका ग्रुप की 4:15 पे